between the parties. To please the court, I put the terms of that agreement on the record.
Okay.
The terms of the agreement are the defendant would plead guilty to count 3. Now, Your Honor, that is a felony of the 3rd degree, aggravated trafficking in drugs, as I'll explain on the record here in a moment, as I did in chambers. And also count 4, F2, aggravated possession of drugs with the 1-year gun specification. Also, the defendant will plead guilty to the probation violation charges in 22 CR 749. We realize that's not going to happen today, Judge, but it's part of the agreement. The defendant would voluntarily forfeit items seized on scene by the narcotics agency. And the state, if resolved by way of this plea agreement, would recommend prison terms on both cases totaling 4 years. And actually, Your Honor, I did make it, you asked me in chambers about this. I said, well, it's going to change because of the F2. We're going to recommend 4 years. Not sure what that breakup's going to be in terms of the Reagan-Tugs.
Okay.
But the state promises it's not going to be more than 4 years recommendation definite time. The defendant does not have to agree with that, Judge. He doesn't have to join in. He can ask for the minimum or any available sentence. Thank you.
All right, Mr. And you're amending count?
Oh, yes, Your Honor, if I may. The state would move to amend count 3, and the amendment is that in the second paragraph in count 3, the amount of meth equals or exceeds the bulk amount but is less than 5 times the bulk. That would stay the same. We would remove the second phrase of that sentence. And the offense was committed in the vicinity of a juvenile. The state is going to move to delete that portion of the charge. The effect of that, it makes it a felony of the 3rd degree, presumption in favor of a prison term. It's not mandatory prison term, the F3. So the state moves to amend count 3 in that way. And then as parcel of the agreement, the state is moving to incorporate the dates from count 1 and count 2. So it would be on or between August 9th, 2024 through August 20th, 2024.
All
We would
right.
incorporate 1, 2, and 3, Judge. Thank you.
All right, any objection to those amendments, Mr. Fatico?
No, thank you, Your Honor.
All right. All right. Mr. Washington, how old are you?
I'm 22.
And how far did you go through school?
I made it to 11, I believe a 10th to 11th grade.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of this indictment?
Yes, sir.
All right, it's been represented to me that you're going to plead guilty to the amended count 3, aggravated trafficking in drugs, a felony of the 3rd degree, and also count 4, aggravated possession of drugs, a felony 2, and the firearm specification to count 4, and then the remaining terms will be dismissed, charges will be dismissed at the time of sentencing. Is that your understanding?
Yes, sir.
All right, any questions about that?
No, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk some more to Mr. Fatico, let me know and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you have the right to get a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I sentence you to prison?
Yes, sir.
All right, now in count 3, which incorporates the dates from count 1 and 2, aggravated trafficking of drugs is amended as a felony of the 3rd degree, and it carries a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
And in is there a mandatory fine on that?
There is, Your Honor, yes.
On count 3?
Yes, Your Honor.
What is it?
5,000.
5,000. All right, there's on that fine, there's a mandatory fine of at least 5,000 up to 10,000. Do you understand that?
Yes, sir.
And then what's it, up to 10 to 20 on the, what? The next-
75 to 15 on the F2.
On the F2?
On count 4.
Okay.
Yes,
All right.
Your Honor.
All right. On count 4, aggravated possession of drugs, it's a felony of the 2nd degree, and that's what's called a qualifying offense. That means when I sentence you on that case, on that count, there's a definite minimum that I will sentence you to, along with an indefinite maximum. So I'm going to give you 2 terms on that one count. The indefinite maximum will be 1/2 of what the definite minimum is. Do you understand that?
Yes, sir.
All right, so for instance, if I gave you 2 years as a definite maximum, then the indefinite maximum would be 3 years. Do you understand that?
Yes, sir.
Okay, now the maximum penalty on that felony of the 2nd degree, as far as the definite minimum, is 8 years. So it could be 8 years. If I gave you 8, it would be an indefinite maximum of 12. Do you understand that?
Yes, sir.
And then the fine is a mandatory fine of at least $7,500 up to $15,000. Do you understand that?
Yes, sir.
All right. Now that count 4 is a mandatory prison sentence, so you will be sentenced to prison on that count. Do you understand that?
Yes, sir.
And count 3 is there's a presumption of a prison sentence. That means that you have to overcome that presumption at the time of sentencing, or it would be imposed on that count also. Do you understand that?
Yes, sir.
With regard to count 4, there's a firearm specification attached to that count, and that requires a mandatory 1-year prison term. Do you understand that?
Yes, sir.
And that term must be served prior to and consecutive to the sentence on count 4. Do you understand that?
Yes, sir.
Anything else with regard to the penalties, Mr. DePiero? I'm going to do the consecutive, but as far as that individually?
In terms of the prison sentences and the fines, no. There's
Okay.
just some other things like possible driver's license
Right.
suspensions, things like that. Thank you,
Okay.
Judge.
All right, now, and there's a voluntary forfeiture of all the items, Mr. DePiero. Do you understand that?
Yes, sir.
Okay. Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. So if I gave you a consecutive sentence that was a maximum sentence, that means you could get a maximum of 8 years, as a 8 years, actually 11 years, as a,
Plus one.
huh?
Plus one.
Right. So, All right, so I could give you, if I gave you a maximum consecutive sentence, that means it would be a total of 12 years up to 16 years in prison. Do you understand that?
Yes, sir.
And that encompasses the firearm specification in both counts. Do you understand that?
Yes, sir.
And if I gave you a maximum fine, it would be $25,000. Do you understand that?
Yes, sir.
Do you have any questions about any of the penalties?
No, sir.
Are you on post-release control to the parole authority?
No, sir.
You understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes, sir.
Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes, sir.
Do you understand that upon your release from prison that you will be placed on post-release control for at least 18 months up to 3 years under the parole authority?
Yes, sir.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If your violation of post-release control was a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that as far as your prison sentence during the course of your mandatory prison term, you are not eligible for judicial release?
Yes, sir.
Outside, if there is some time that's not mandatory, then you would be eligible for judicial release. Do you understand that?
Yes, sir.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Fatika before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
All right, Mr. DePiero, if the case went to trial, what would the evidence show?
Your Honor, the evidence would show that on August 20th, 2024, in Lake County, Ohio, as part of a controlled by being run by the Lake County Narcotics Agency and other Lake County law enforcement agencies, the defendant knowingly sold methamphetamine, a Schedule II controlled substance, to a confidential informant in a monitored transaction. The methamphetamine that he sold was confirmed to be methamphetamine Schedule II by the Lake County Crime Lab. On August 20th, 2024, the amount that the defendant sold to the confidential informant was 3.94 grams. So bulk is 3 grams. That's over bulk, between bulk to 5 times bulk. The evidence would show that both on August 9th and on August 12th, 2024, the defendant also sold methamphetamine to confidential informant, 2.43 grams on the 9th, 2.11 grams on August 12th. And this was in a parking lot at the Seneca Grove Apartments in the city of Paynesville, Lake County, Ohio. Based on the controlled buys, the Narcotics Agency secured a search warrant and executed a search warrant of the defendant's residence. And while inside, they found that the defendant was in possession of a baggie of methamphetamine pills, and that weighed 20.32 grams. So that's more than 5 times bulk, 5 times bulk being 15 grams. They were in a baggie above, in a cabinet in the kitchen above the microwave. Also, Your Honor, the defendant was in possession of a gun in a suitcase that he had packed. He was going to be visiting out of town, and it had a firearm, and it also had the defendant's wallet with his ID card in there along with the gun. That gun was forwarded to the Lake County Crime Lab and found to be an operable firearm. And that also was in the apartment in Seneca Grove, Lake County, Ohio.
All right, thank you. Mr. Fatika, anything to add to those facts?
No, thank you, Your Honor.
All right. Mr. Washington, did you hear what Mr. DePiero said the facts would show if this case went to a trial?
Yes, sir.
And are those facts true?
Yes, sir.
What is your plea to the amended count 3 aggravated trafficking of drugs, a felony of the 3rd degree?
Guilty.
What is your plea to count 4 aggravated possession of drugs, a felony 2?
Guilty.
And what is your plea to the firearm specification to count 4?
Guilty.
All right, Mr. Fatika?
Okay. This is the original that.
Your Honor, the defendant has signed the written plea of guilty form, so did Mr. Fatika, so did I. Mr. Fatika is approaching with the court's permission to hand that to Your Honor.
All right, Mr. Washington, is this your signature on this written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
All right, I will accept the written plea of guilty. Defendant was present, Mr. Fatika. Advised of all of his rights, made a knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge, consequence of his guilty plea, and the maximum penalties. Find it to be knowing, intelligent, voluntary. I will accept the plea of guilty and find him guilty of amended count 3, aggravated trafficking of drugs of felony 3, count 4, aggravated possession of drugs of felony 2, and the firearm specification. I'll refer this for an updated pre-sentence report. Sentencing will be January 8 at 8:30 a.m. and we'll deal with the probation violation on 22-749 at that time. Anything else, Mr. DePiro?
No, Your Honor. Thank you.
Mr. Fatika?
No, thank you, Your
All
Honor.
right, we're adjourned.
All right.